I'm delighted to introduce Professor Kim-Lane Scheppele as our distinguished lecturer for this year. The distinguished lecturer is an important part of the Academy each year. We look for someone outstanding who is currently working on something of exceptional interest that they can come and speak to us about. And this year, I just want to introduce very quickly the reasons why that is very much the case for Professor Scheppele. She is the Lawrence S. Rockefeller Professor of Sociology and International Affairs at Princeton University. She's been working in Princeton for over a decade, and during that time was built up this incredible program as director of the Law and Public Affairs program, LAPA, in Princeton University. And before then, she worked in Pennsylvania, before then in Michigan. So let me say a little bit about her work. I mean, she's got an extraordinarily wide range, so I have to try and just encapsulate it in a few words. I guess her main center of interest is in comparative constitutional law. And what I think is so interesting about her work is that she uses a range of methods. So she's a sociologist and a lawyer. She's interested in history. So she uses ethnographic, historical, doctrinal methods to think about constitutional questions. And she's especially interested in the emergence and collapse of constitutional systems and constitutional systems when they're under stress. And I think of particular note is how she moved to Russia and Hungary and spent a really extensive, really immersing herself in life, law, and society of these countries in the post-1989 period. And she's written really very, very incredibly interesting things about that transitional period, especially focusing on the constitutional courts in these countries and the ways in which this new constitution, the post-transition constitutions, became part of a new consciousness in those states. And I'd just like to give you the titles of a few of her works, because I think they're so evocative of the kinds of issues of her work, but also the kinds of issues we're interested in looking at in the Academy this year. So she's written about legal secrets, a book about legal secrets, so, which is so fascinating. Constitutional ethnography, democracy by judiciary, and why democracies need more than parliaments. The constitutional defense of social rights in times of budget collapse. So you can see there are a lot of themes here that we have been interested in the Academy so far. Law in times of emergency. So all of this background, I wanted to give you all this background to all the work she's done over her career, to say that this really made her centrally placed in all kinds of ways to respond to and to participate in, which she has done very actively and very, very publicly, to the emerging constitutional crisis, in particular in Hungary and Poland. And it has also led her to develop even more fully her interests in EU law than she had before, though she had a long-standing interest in EU law, but to really try and work out and make a case for what can the EU do in such situations. So, as you'll know, and as I'm sure she's going to tell us today, this is a field where events are changing on an hourly basis, actually. So we're incredibly grateful to her for coming here today to share her knowledge and her thoughts with us. So thank you very much.
I'm really honored to be here. This is a really legendary place to talk about EU law. So, as you've probably noticed, although you might be too busy here to notice, things have been happening this week. Tuesday in Warsaw, there were huge crowds out in front of the Supreme Court of Poland because Tuesday at midnight, the president of the Polish Supreme Court was fired. There were 27 judges who were in line to be fired that night, and in fact, one of the signs of confusion is that we actually can't tell how many have been removed. Even though the president of the court was fired, she showed up for work yesterday morning. This is the scene yesterday morning at the Polish Supreme Court. You can see her there in the front, greeting her supporters who accompanied her to the court to make sure she wasn't arrested on her way in. Why was she fired? Well, she was fired because the Polish government passed a law earlier this year that lowered the judicial retirement age from 70 to 65. And that meant that 27 of the judges from the Supreme Court, almost 40% of the total, were to lose their jobs when this law took effect, and the law took effect on Tuesday. So the president of the Supreme Court is saying this is an unconstitutional law, I have no obligation to follow it. You'd think in a system like Poland's that the Polish Constitutional Tribunal would weigh in on that question, but the tribunal has already been captured and nobody thinks it can make an objective ruling. So essentially the Supreme Court has taken the view that in the absence of the Constitutional Court, it can make the determinations of the constitutionality of laws under the Polish Constitution. And in her interpretation of this, she and a number of the other judges are refusing to leave because they claim the law is unconstitutional. Now, there's an exception. It turns out that judges beyond the age of 65 who wanted to stay could apply to the justice minister for a special exemption, allowing them individually at the discretion of the justice minister to stay on. And so of the 27 who were targeted with this law, 16 asked for exemption, and I was calling even this morning friends of mine in Warsaw to find out what happened to the 16, and nobody knows. But 11 refused to ask for exemption, and they're showing up at work. So far, the Polish government has said, we don't intend to arrest them, but we don't intend to honor their decisions. So I think that's where things stand. So this is the confusion at the court today. The government says it's replaced the president of the Supreme Court. But when the press in Poland has interviewed the guy that they named as the new president, who, by the way, is 66 years old, okay, he says, the new president says, nobody's told me whether I'm really the president or not. Okay, so we don't know who the president of the Polish Supreme Court is as of this morning. Yesterday morning, the current president, or the first president as of Tuesday, said she was going to stay and fight. But by the afternoon, she said, perhaps she will take a holiday. So I can't figure out whether she's shown up yet for work this morning. I mean, literally, this is happening as we speak. And to give you some sense of just how ominous this is against the backdrop of what's been happening in Poland, Lech Wałęsa, who many of you will remember as kind of the leader of the opposition, anti-communist opposition in Poland through the 80s, said today, this is the path of civil war. Things have gotten so bad in Poland that really we don't know whether this is going to erupt into violence or not. And there are protesters out in the streets sort of every day. So yesterday at the European Parliament, the Prime Minister of Poland, Mr. Morawiecki, thank you, showed up and said, judicial reform is a national competence. Essentially, it's none of the EU's business. And then he went on, I just have a couple of quotes, but the gist of what he said was, we're a democracy, we're elected, you guys aren't, especially to the Commission, and so this is a national competency, stay away. Okay, now in anticipation, this is not news to the EU, which has been following this very closely, and the European Commission in particular, as I'll describe, has been very actively involved in the Polish situation from the beginning. We're now a couple of years into this. And on Monday, the European Commission started an infringement procedure against Poland exactly about these laws. Okay, now the law was to take effect Tuesday. The problem is that they filed the action on Monday. Now, you know, what you think and what the Commission said was that they were sort of waiting for the Polish government to back down. But when it became clear the government wasn't going to back down, they've now filed this infringement action. And I just put up a little sign, many of you will know that, of course, infringement actions take time. Under the normal procedure, the government sends a letter of formal notice to the commission sends a letter of formal notice to the government, and then the government gets 2 months to reply. Okay, so they've speeded it up. The government will only get 1 month to reply. But the government's already going to replace all the judges by then, right? And then there'll be another set of opinions that the commission will decide whether Poland has responded. There'll be a reasoned opinion. By the time it gets to the ECJ, well, you can imagine the facts on the ground will be quite different. But this is what the commission said as it filed this this infringement procedure on Monday, that in the view of the commission, Poland fails to fulfill its obligations under Article 19, Part 1 of the Treaty on the European Union. All right. Whoops, I'm going backwards there. So what is Article 19.1, and how do we think about judicial independence in the treaties? Well, judicial independence is obviously absolutely crucial for the operation of the EU as a rule of law system. And yet, judicial independence is not mentioned as such in the treaties at all by those words. Instead, you've got these two articles, 19.1, which is what I think of as the structural provision, sort of laying out how the union is structured. And those of you who know 19.1 will probably know it, or Article 19 in general, will know it as the article that sets up the European court system. But it has this one clause at the end of Article 19.1, which says, member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by union law. So the question is, what's effective legal protection, and how serious are they about in the fields covered by union law? And is the structure of a national judiciary part of that or not, right? So we're going to think about that today. There's also in the treaties Article 47 of the Charter of Fundamental Rights, which sets up an individual right to an effective remedy and to a fair and public hearing. But the fair and public hearing is conditioned on having an independent and impartial tribunal previously established by law. So it sort of assumes there's a structural guarantee in the background. Okay? So the question is whether those are enough to help us. And a lot of my talk today is going to be on, can the European Union leverage those into something that can actually deal with the crisis of the courts in Poland? Behind it, though, is a bigger issue, which really goes to the question of rule of law and legality that's preoccupying the Law Academy this summer, and that is, what do you do when a member state has overtly reneged on its commitments to certain elements of Article 2, which lays out the basic values and principles of the European Union? It says the European Union is founded on the values of human dignity, freedom, democracy, equality, rule of law, human rights, etc. And then it asserts as a factual matter, these values are common to the member states. So the question is, what if they aren't? What if you have a member state of the European Union that no longer buys this particular formula? And of course, the first thing you notice is that there's no way to throw a member state out. There's a way for the member state to quit, but if it leaves sort of mentally only, but doesn't leave legally, then what do you do with it? And the most serious sanction in the EU toolkit is Article 7 of the Treaty of the European Union. I know this is lots of text, and by the way, I tend to put slides up really fast, and I'm happy to share them. I do this so that you'll, pay attention, but also to sort of just anchor the talk a bit. Article 7, this is just an excerpt from it. It's fairly complicated, and the crucial thing to notice about Article 7 is that despite having 3 numbers, it has 2 parts. In Part 1, there's a procedure through which the European institutions can warn a member state when there's a risk of a serious breach, okay? And it still requires really heavy lifting on the part of both the Council and the Parliament. So the Council has to act by 4/5. The Parliament, it doesn't say what the rule is, but in the Parliament's rules, it's by a 2/3 majority, and that's what you need to say there's a risk. Think about what happened this week. Is that a risk, or is that something really happening, right? So if you think there's already been a breach, then you get to Articles 2 and 3, and this is in 2 stages. In Article 2, you need a unanimous vote of the European Council minus the member state in question that there has been the existence of a serious and permanent breach. Unanimous agreement minus the member state. And only after you've passed that hurdle at the European Council can a QMV decision in Part 3 then issue sanctions against the member state, which may include removing their vote in the European Council, cutting funds, a number of other things that everyone's now trying to think about. So as you can see, Article 7 is very tough to use, even at the warning stage. And we're going to see that European institutions have struggled with this from the beginning of this rule of law crisis. So that's where we are right now. So let me just tell you where I'm going to sort of hope to take you in this, in the next little while here. First, to give you some background, what happened this week in Poland was long foreshadowed, both in Poland and then if you look at what happened in Hungary since 2010, the Hungarians have been there before, including lowering the judicial retirement age, including an infringement procedure for that, so none of this is particularly new. And so, you know, what happens when the independence of the judiciary has been fundamentally compromised in more than one member state at once? What has the EU done as this whole process has gone on over what are now sort of 8 years, starting with Hungary? You can see that Poland and Hungary are still challenging states, so the EU has not succeeded in rolling back these changes. And the question is, why is the EU so ineffective at all of this? And then fourth, you know, if the EU wants to do something about it, what can it do? All right, so I'm going to start with a tale of two countries. I might say that the only thing I can say that's good about Poland and Hungary right now politically is that bad political times produce good political humor, so I will show you a lot of political cartoons as we go along, including this one. So I'm going to give you a little background on Poland and Hungary. So first of all, what this is usually described as is the rise of populism. You know, as in the masses have gone crazy, they voted for these governments that are Eurosceptical, and that this is basically an ideological problem. But I think even though it's also an ideological problem, it's more fundamentally and more seriously and more challengingly a problem about state structure and a problem about whether you still have a functioning democracy anymore. What looks like populism has turned quickly to autocracy. So what do I mean by autocracy? It's kind of a strong word. In an autocratic government, there is one center of political power. No separation of powers, no checks and balances, one center of political power. The courts and other independent institutions have been captured. That's what it means to have one center of political power. The political opposition and civil society are treated not just as oppositional, right, but as illegitimate. They shouldn't exist because there is one center of political power. And more crucially, in the later stages, that people cannot change the government even when they want to, which is to say, even elections fail to record what it is that most people want. Now, both Orban and Kaczynski, Orban's much farther along in this regard, Kaczynski's catching up in Poland. And what's really interesting about this new generation of autocrats, and this is true in Europe, but it's also true of the Latin American ones and some of the other ones outside the EU, is that all these autocrats start off being elected. I mean, I work in Russia as well. You could say the same about Putin in 2000 with his first election, which was real, and then the elections have become progressively less real over time. They come to power in elections. They use their electoral victory to attack constitutional institutions. And the real difference between just a political disagreement, like these guys have policies I don't like, and the real challenges to constitutional order is whether the new autocrats or whether these new elected officials go after the checks on their power, right? So it's one thing to bring in a new political program to reverse the economic policy of the prior government, excuse me, but it's quite a different thing to start looking at all the ways that leadership can be checked and then to attack those. So this is, I think, what's happening. Excuse me, coughing. But what these guys do, because they were elected, right, is they say, well, we're democratically elected. That justifies absolutely everything we do. And then they criticize their opponents for simply being political disbelievers. You know, well, our opponents are on the left or the right or wherever they aren't, right? But that's really not what's going on here. This kind of new order concentrates power in a unified party and a single leader, which is why I say it's really autocracy, not populism. And to give you a little bit of evidence, that's always my favorite, for why this is not populism in Hungary and Poland, this is the result of a Eurobarometer survey done in 2016, right after Brexit, right, in which citizens of lots of different countries were asked, like, should they put up a referendum and have you vote to exit the EU? The two countries with the highest level of support for staying in the EU in 2016 were Hungary and Poland. And this is persistent across all the Eurobarometer indexes. the public in general in these countries is not Eurosceptical. And as I keep saying to the European Commission and others that I work in the European Parliament, I keep saying they'll become Eurosceptical if the EU doesn't act. You know, but right now, in both countries, you have these overwhelming majorities that are pro-EU. Those are majorities that are much higher than the level of support for the current government, which is why I think populism is not what's going on. But instead, constitutionalism as such is under attack because all of the targets that these leaders are going after, both Orban in Hungary and Kaczynski in Poland, are removing constraints on their own discretion. And they start by attacking the courts, and then they move to the media, civil society, other independent checking bodies. Okay, so there was, you know, in fact, when these countries, these post-communist countries in Europe joined the EU, they thought there was a guarantee that this couldn't happen. And why was that? Because on the way in the door, the EU set up these so-called Copenhagen criteria, which were designed to assess whether a country had really moved into the phase where democratic accomplishments, a market economy, and the administrative ability to enforce EU law were all present in the member state. But I think it's now clear that with Hungary and Poland, if they were to join today, they would not meet this first set of criteria. But like I said, no way to check once they've come in the door. This is the problem, right? There's no obvious way to prevent a state from going rogue. Okay, so once a state gets admitted, then the EU has lost its leverage at trying to get a country to change. So let me just run you through the Hungarian story, particularly focusing on judicial independence, and tell you a little bit about Poland so you can see what the EU is up against. Viktor Orban, who had been prime minister between 98 and 2002, although he was governing in coalition, so we didn't quite know exactly what he was capable of doing on his own, was elected first just with his Fidesz political party. Those are the orange seats in the Hungarian parliament to give you a sense of the size of his mandate in 2010. It was a free and fair election under a system that put its thumb on the scale of a plurality party to give them more seats. So Orban won 53% of the vote in a multi-party system and got 68% of the seats. In a system where under the Hungarian constitution, you can amend the constitution with a single 2/3 vote of the unicameral parliament, which is to say, with that majority, effectively law didn't constrain him. And sure enough, it didn't. They amended the constitution they inherited 12 times in the first year in order to make possible what happened next, which is bringing in a brand new constitution, which was adopted about 1 year into office. I might say that this constitution was adopted, this very worrisome constitution was adopted at the time that Hungary held the rotating presidency of the EU. And in fact, they did a lot of the worst things exactly during that period, because if you hold the rotating presidency, you set the agenda for the council, right? So they were immunized exactly by the rotating presidency. So this was accompanied by 800 new laws. In fact, my friends who are law professors in Hungary, I used to work at the Constitutional Court there for 4 years. I should just explain because I'm kind of committed to constitutionalism in Hungary. My friends who teach constitutional law used to say they'd wake up in the morning and read the papers to figure out what constitutional law was that day, as all this stuff was changing very rapidly. All of these changes have now resulted in the concentration of basically all power in the hands of the single governing party. There is no institution in Hungary, from local governments all the way through to the Election Commission, Audit Office, Public Prosecutor's Office, the Media Council, on and on and on. Everything is in the hands of the governing party, and as we'll see, also the judiciary. So what did the Fidesz government do first? Well, those of you who know something about Hungary and the post-communist transition will know that Hungary had the most powerful constitutional court in the region. And for those of you who teach the decisions of the Hungarian Constitutional Court, you should now know that all of them have been invalidated, except for the few in the last couple of years. But this court was instituted as the most powerful check on the powers of this unicameral parliamentary system, which otherwise doesn't have a lot of checks. And the first thing the Orban government did was to attack the Constitutional Court. And they first attacked the weak spot, which was how judges are selected. So under the old system, judges were selected in a two-phase process. So phase one, the candidate had to win a majority of political parties in the parliament, which usually meant the opposition got to screen out a whole lot of very partisan candidates. And then in phase 2, the candidate had to win a 2/3 majority of everyone in the parliament. So the Fidesz government came in and they dropped stage 1. Right? So all the judge needed was 2/3 majority, which the governing party had. And they immediately then changed the number of judges on the Constitutional Court, which would have looked like court packing, except that Viktor Orban borrowed a really clever strategy from Mr. Erdogan in Turkey, who had just done the same thing half a year earlier. What they did was they changed the jurisdiction of the Constitutional Court to take constitutional complaints in the German sense for the first time, which was going to give the court a whole bunch of new cases. And then they said, because we're such supporters of the court, they're going to need more judges. And then they added more judges, okay? By 2013, so 3 years into Orban's term, the court was entirely in the hands of Fidesz loyalists, and they could produce a reliable majority for everything. This is probably too small to read, but there was a study done by the 3 major human rights organizations in Hungary of the voting records of the early Fidesz judges, and most of them voted almost 100% for any government program, no matter how outrageous. And so once Fidesz captured enough of these judgeships, the Constitutional Court was effectively neutralized. But that wasn't enough. Like I said, they changed the jurisdiction of the court, but what the court had was, almost its entire caseload, were abstract review cases. Anyone, in fact, anyone in this room could have done it before 2010, could challenge any law in Hungary for its constitutionality under the Hungarian Constitution. You didn't have to be a Hungarian citizen, you didn't have to have standing in any conventional sense or demonstrate any nexus with the legal issue at stake. Anyone could file a constitutional complaint, and that's why the court was so active. They've now cut back the abstract review jurisdiction so that it hasn't been used at all since Fidesz has come to power, and now the primary engine of the cases at the court are individual rights complaints that have to go through the legal system before they get to the court. And it's extremely difficult to leverage criticisms of a structural arrangement through individual rights cases. So it's just very difficult for the court to even reach these issues anymore. Along with that, this constitutional amendment in 2013 that coincided with the court being captured nullified the entire jurisprudence of the court from 1990 to 2011. So any case, and that's all the human rights jurisprudence, by the way, and I might add that when the Hungarian Constitution was criticized in 2011 by the Venice Commission, the Hungarian government's response was, oh, we don't have to put that in the Constitution because it's in the jurisprudence of the Constitutional Court. And then 2 years later, they canceled the whole jurisprudence of the Constitutional Court. So all of that is gone. And then, because the Constitutional Court was fighting until the time it was captured, they took all the decisions since the new Constitution went into effect that had ruled against the government, and then just put all those laws directly into the Constitution itself, which is to say the Constitution no longer constrains the government in Hungary. The government also attacked, after that, the ordinary courts, so the non-constitutional courts. This is a picture of Tünde Hando, who is the president of the National Judicial Office, a new office created by this government. She single-handedly picks all the judges. The president has to countersign, but the president is also a Fidesz guy who rubber stamps everything. And she is the best friend of the prime minister's wife, has known the president since they were prime minister since they were in college together. And her husband wrote the new constitution, so she's well-connected. Many people claim that that makes her not as objective as she might be in picking the judges. This arrangement has gotten sharp criticism from the Venice Commission, the International Bar Association. It hasn't stopped the government. She's been appointing judges now for 6 years, I guess. And once judges are appointed, she can fire them, she can reassign them, promote them, demote them, discipline them, all her doing. Okay, so this is one. So any judge in Hungary that rules against the government has a government-friendly person there to supervise their activities. They also, and this is where Poland got it from, Hungary lowered the judicial retirement age for all the judges in the ordinary courts from 70 to 62. And in doing that, they got rid of about a third of the Supreme Court and almost all the court presidents, because of course it's a civil service judiciary. Who are the older judges? They're the ones who've been promoted. So this is how the Hungarian government opened up all these positions for Ms. Hando to install judges in. The European Commission got very active, brought an infringement action against Hungary on that obvious European Union legal ground, age discrimination. They expedited the case. They won the case. The commission won the case. What do you get when you win a discrimination case? Compensation. So that's exactly what happened. The Hungarian government paid a tax on firing all the judges, compensated them. The commission kept insisting that Hungary reappoint them, but it had absolutely no leverage to do so on that basis, right? But they could have filed, what many of us were urging was for them to think about judicial independence, but their argument was, going back to what I said before, there is no legal basis in the treaties for insisting on judicial independence in a member state. Okay, so basically Hungary paid a tax and got away with appointing all of its new judges. There was, however, one person they couldn't get rid of that way, and that was the president of the Supreme Court of Hungary, this guy, András Baka, who had just returned to Hungary after spending 17 years on the Strasbourg court. And he had been 3 years in Hungary as president of the Hungarian Supreme Court, and he was under 62. So what did they do? They renamed the Supreme Court the Curia, which had been the name of the High Court in Hungary in the Middle Ages. And then they claimed it was a new institution and all the old judges had to reapply for their jobs. And they had to apply under a new filter, new criteria. And one of the criteria was that to be on the Supreme Court of Hungary, you had to be a judge in Hungary for at least 5 years. Every single judge passed except Justice Baka, who was thereby fired. He took his case, of course, to the Strasbourg court where he used to work, and they awarded him, they found that there had been a violation in his case, but of what? Judicial independence is also not in the European Convention. They found that there was a violation of his free speech rights because they found that he had been fired for criticizing the government. So you can see that there's already a problem reaching this dilemma, reaching judicial independence, either from the EU law side or from the European human rights side. Yeah. Yes. So this is going to be the progress. So the Commission's new infringement procedure cites Article 19. And that's a lot of where the story is going. The Commission's been learning, but they had to make all these mistakes first on Hungary. Yes, because there's been an ECJ decision from February in the case of the Portuguese judges, and that's exactly, so in fact, where you've previewed my ending. Where this is going is that the EU is going to flop around and that the Council and the Commission are going to be kind of helpless, and finally the ECJ is going to try to take charge, although even that's going to be problematic, but there has been progress. But this is, you know, this case dates to 2013, right? So we're still kind of early in the evolution, but you could see that the Commission didn't know what hit it, and obviously, and also, and similarly with the Strasbourg court, and they felt they just didn't have the tools for dealing with it. So anyway, all these judicial reforms in Hungary haven't stopped. So just a couple of weeks ago, the government enacted the 7th Amendment to its new constitution that went into effect 1st of January 2012. And under the new constitutional amendment, there's now going to be a new system of administrative courts in Hungary. And we haven't seen the draft law yet, but there have been various versions in circulation for a couple of years now. And at least according to the drafts that we've seen, the new administrative courts would not be required, or the judges of those courts would not be required to have legal training. They could be civil servants. They would not have life tenure or any kind of regularized expectation of permanence in their position. And already what Hungary has done, and this is something I want you to keep in your mind as we go through this, already what Hungary has done is to take all the subject matter areas covered by EU law and given them one set of procedures in Hungarian law, and taken all the matters that are still left to national jurisdiction and given them a separate set of administrative procedures. And the new administrative courts are going to be in that second box, right? That no EU law topics can go to those new courts. So think about whether the EU can reach that if what you've got is essentially unconstrained administrative discretion with no judicial review. So this is what's coming. And the reason why they did this was because the guy they appointed as president of the Supreme Court, Mr. Darak there, has turned out to actually have a bit of a backbone, and he's been standing up to the government recently. So now they're going to try to go around him by developing these new courts. Okay, and is it all over in Hungary? Well, Viktor Orban gave a speech a few weeks ago in which he said, this is him being installed for his 3rd term now, what he said is, in the autumn we're going to launch another constitutional review, and in a year and a half we're going to come forward with a new constitution again. Okay, so stay tuned. That's where we are with Hungary. So let me tell you a little bit about Poland, and then we'll get to what the EU's done and whether they could have done something else. So the Polish government's a lot newer. So this government was elected in 2015. The Peace Party, Peace is the Polish acronym for the Law and Justice Party. By the way, it's a general clue in the post-communist world that whenever parties have names like Justice and Life or Law and Liberty or Justice, it's usually bad news. So you know about naming of parties in the eastern part of Europe. So anyway, the Law and Justice Party is a fairly far-right nationalist party. It's been called a populist party, but like I said, I think it's much more autocratic than populist for all the reasons I've suggested. Mr. Kaczynski, who is the head of this party, and who, by the way, only has a position as an MP. So he's not the prime minister, he's not the president, he's merely an MP, which also raises questions about if the guy who's actually running stuff is just an MP, do you have constitutional means for controlling him in any way if MPs usually have parliamentary immunity, right? So the usual things that would apply, like to a no confidence motion in the government or something, don't apply if somebody's an ordinary MP, which is already an interesting constitutional feature here. So the peace government in 2015 won a majority in the lower house of the Polish parliament, also won a majority in the upper house, also won the presidency. They don't have a constitutional majority, which is going to, I think, become quite crucial in the EU's response. And they start off, again, just like in Hungary, attacking the Constitutional Tribunal. Okay. Now, here it's also a little complicated because the outgoing government had started the problem. The outgoing government had the legal capacity to name 3 judges to the Constitutional Tribunal. And there was a last-minute change of the law by the prior government. They elected 5 judges, 2, no doubt, illegally, as the Constitutional Court later said. The incoming peace government said, we don't recognize any of these 5 judges. We're going to elect 5 judges, and they elected 5 judges, and their president swore in the new judges, 3 of whom were illegal under the old law. And so what you immediately had was this crisis of who's on the Constitutional Court. So the Constitutional Tribunal declares the election of 2 judges by the prior government illegal, unconstitutional, 3 judges by the new government unconstitutional. It's a very balanced judgment that everybody did wrong stuff. And the new government refused to publish the decisions, refused to honor the decisions of the court, and insisted that their judges be seated. The president of the Constitutional Tribunal refused to seat the judges, so then the parliament passed a law that prevented the Constitutional Court from reaching any decision without having those judges on the bench, just the sheer numbers that were needed to make the decision, and they cut back the competencies of the court. And then the Constitutional Tribunal declared that law unconstitutional, and the government refused to publish or follow it. So how did this whole thing get resolved? That was actually another demonstration. Actually, what's been really nice to watch in Poland, if you care about judicial independence, is that Poles go to the streets in the tens of hundreds of thousands. The Hungarians read the law and gave up, okay? Everybody's sort of a lawyer in Hungary, and they said, whoop, they won. But, in Poland, there's still people in the streets defending the judiciary. So here's another protest. The guy in the red poster was the president of the Constitutional Tribunal, whose term ended on that day. And on the day his term ended, the government appointed an interim president who then became almost immediately the permanent president, and she immediately sat all the, quote, illegal judges. And through this, they basically captured the court. The European Commission has taken note of this, and they've actually now filed this reasoned opinion to the Council arguing that Article 7.1 should be invoked. And this is the summary written by the European Commission, which considers, as a result of the laws adopted in 2016 and the developments following the appointment of the acting president, that the independence and legitimacy of the Constitutional Tribunal is seriously undermined and the constitutionality of Polish laws can no longer be effectively guaranteed. Okay, so that's now the judgment of the Commission. So things are changing, right? Now, that's just the Constitutional Court. Here's what happens to the ordinary courts, okay? Poland, just after it captures, it's following the Hungarian script here, right? They want to capture the ordinary courts. So last summer, the parliament passed 3 laws, one that allowed the government to capture the tribunal, the commission that appoints all the judges. The second would have allowed them to fire every single judge on the Supreme Court, and the third allowed them to fire the ordinary court presidents. Again, demonstrations in the streets. There was a big international outcry to get the president to veto the laws. And then some of you may remember this, the president actually vetoed 2 of the laws, and people are saying, wow, rule of law is restored in Poland. Okay, now he vetoed the law that would have packed the National Council and the Judiciary, and he vetoed the law that would have allowed them to fire all the judges, but he signed the law that allowed them to fire all the court presidents, which they have all now since done. Okay. And then Mr. Duda, the president, came back with his own versions of the 2 laws, like after the international outcry was toned down, after the weather got too bad to get a lot of people out to the streets for demonstrations, and the 2 laws had the same effect. So now the government has actually packed this National Council on the Judiciary with its own appointees. And the second law is the one we've seen go into effect this week, where instead of firing all the judges, they've followed the Hungarian strategy of lowering the judicial retirement age. And this is now, getting rid of 40% of the judges, which is enough. You don't need all of them. So that's where we are this week. All right. So now what did the EU do to stop all of this? Well, not enough, obviously, but a lot of that was because they couldn't figure out what to do. So I can say, the Barroso Commission was incredibly well informed. José Manuel Barroso himself knew all the details of the Hungarian case as it was happening. They were trying. They were just running through like every possibility of what they could do. And part of the problem in the Hungarian case was that everything the Hungarian government did was legal under Hungarian law, right? We're going to see in the Polish case where a lot of this was done illegally under Polish law. That's going to be really different as the Commission sees it, because not following your own court and your own law and your own decisions will look like a bigger problem, but it's the same result, right, in the 2 cases. And so the worry here also, by the way, is that if you think back on the lectures you've already heard in this sequence, this is happening in 2010, 2011, 2012, when the EU has a few other things on its mind, right? This is the Euro crisis. This is the run-up to Brexit. Brexit is being threatened all the time. And then, of course, by the end of this period, you've got the migration crisis, and basically the Commission and the Council, the Commission in particular, just get overwhelmed by these things. And actually, people at the Commission used to say to me in the early days of the Hungarian consolidation that if the Commission jumped in and did anything about the internal, constitutional affairs of a member state, they said, we're worried that maybe, the British public would then vote for Brexit. Well, you can see they lost them both. All right, so the Commission brought a couple of infringement actions on this whole thing. It was really surprising how little they did, because they couldn't find the hooks in EU law if they were looking at just simple black letter law. So they brought this case for age discrimination against the judge's law. They also brought in action because the Hungarian government also fired the data protection officer, and they brought that case and won, but here too, it's compensation. The government got to keep its data protection officer, so none of this really had any effect on the ongoing consolidation in Hungary. The Commission tried to find ways to cut funds to Hungary, so Hungary was getting about 6% of its GDP in various funding streams from the EU. And so they kept, and Hungary had been in the excessive deficit procedure, as had a lot of countries, which allowed the EU more intrusive monitoring. And the Commission kept Hungary in the EDP for much longer than its underlying financials would have indicated. I think they would never say that, but I think in part because they were trying to at least exercise more monitoring. They several times, and one time for almost a year, cut or sort of suspended funding streams to Hungary for various problems with the tendering process for European contracts and for discrimination and requiring that employees on some of the contracts belong to Hungarian unions. Excuse me, sorry. But ultimately they couldn't do things, but they were trying. So in the end, what they did was they forwarded something. They start looking at Article 7. And then they say, well, who gets to do the research to find out if Article 7 should be triggered? And Viviane Reding, who was then the vice president of the Commission, shepherded through this thing called the Rule of Law Framework, which was designed to give the Commission the capacity to sort of comprehensively assess whether a member state was violating Article 7. Okay, that's what it looks like. You can't read it because it's small print, and that's basically what it feels like, which is to say it's endless dialogue. Like, we think you have a problem. No, we don't have a problem. Well, we really, really think you have a problem. No, we really don't think. As it goes, anyway, so this is sort of how the system's supposed to work for quite a long time. And it's supposed to end if there's no resolution by the state with some recommendation for Article 7. But the European Council's legal service immediately says this goes beyond the powers of the Commission. This is still an unresolved issue. We expect this thing to come to the Court of Justice about whether the Commission actually has the power to do this. But even though the Commission put this thing into effect, it put it into effect right before the European elections. And so it was never invoked in the case of Hungary. After the European elections, the European Parliament called on the Commission to invoke this rule of law mechanism for Hungary. It still has not invoked the rule of law mechanism for Hungary. And the Parliament now has sort of gone on its own, as I'll explain. The Juncker Commission has started bringing more infringements, but all for, like, this individual law has that problem, this next individual law has that problem. And we know from how the Hungarian government responds that they will modify each law slightly, but not really change the underlying framework. So there's a bunch of these infringements now pending. Some of you may have heard that the government of Hungary passed a law that looked like it was of neutral application, but it singled out Central European University for closure. I might say CEU met all the requirements in the law by the deadline, and now the government says, oh, but the EU tells us that we should give them more time. So we're going to give them more time. But CEU was ready, so now CEU is just in limbo. In the meantime, this case is before the ECJ, not speeding along. So there's a number of actions, including in the migration field, where Orban's winning over European public opinion, so not clear that's the best place to stand. The Parliament, through all of this, has been much more active. So Rui Tavares, who will actually come to Florence this afternoon, as I understand, you should all meet him. He's a terrific former MEP. Was the rapporteur on this report that did a comprehensive assessment of Hungary in 2013 and said there's a serious, comprehensive, systemic rule of law problem here, and if Hungary doesn't fix it, Article 7 should be invoked. The Commission and the Council ignored the parliamentary report. Just a couple of weeks ago, now there's a new report because the European Parliament recommended that Article 7.1 be triggered against Hungary, and they delegated to the Civil Liberties Committee the capacity to basically come up with a report and the evidence for such a vote. This committee just voted a couple of weeks ago by a 2/3 majority, which is what they're going to need in the whole European Parliament, to go forward with triggering Article 7.1 against Hungary. But, it depends on what the other branches do, and they still have to get this through the 2/3 vote. So here's the problem. In the 8 years this has been going on, the European Council or the Council of Ministers have never said anything about Hungary. It's not on the agenda. They refuse to discuss it. They've not been involved. Everything dies when it gets to member state peer evaluation. But things are a little different with regard to Poland. Okay, so what happened with Poland? Poland's government comes into power in fall of 2015, right? And what happens? In January 2016, as soon as they undertake to capture the Constitutional Court, and again, remember, there's published decisions or decisions of the Constitutional Tribunal that the Polish government is refusing to publish, right? They're seating illegally elected judges, things of that kind. Then suddenly, under Franz Timmermans as the Commission Vice President, the Commission invokes the rule of law mechanism against Poland very quickly. It's a totally different case than Hungary. But the Polish government, while it's having all the dialogue under the rule of law mechanism, there's an opinion, there's a recommendation, the government says, oh, you're singling us out, there's double standards, no, we're not doing that, goes back and forth. And in the meantime, the Polish government is hastening to capture all the courts, right? It's doing all this stuff while it's under monitoring. So here's again the rule of law framework, and it takes a very long time. Franz Timmermans has been really persistent. He's been really patient, and I must say he's also facing a lot of headwinds in the Commission, which is not fully behind his efforts. After 2 years of dialogue, when the Polish government was still continuing to attack the independence of the judiciary and now moving on to the media and other things, finally the European Commission in December of last year says we are writing a reasoned opinion to the Council for them to invoke Article 7.1. Now remember, Article 7.1 is the thing that says we think there might be a risk of a breach. And there are no sanctions attached to Article 7.1. And it's taking this much to get to the warning stage, right? So has it been triggered yet? Well, no. Now, the General Affairs Council finally started acting, so they had a meeting last week, seeing that, more than a third of the Polish Supreme Court judges were going to be fired. They had a meeting last week, and they said they think this is really serious. They recommended that the Commission bring an infringement action, which is the one I just mentioned. And you're thinking, what about Article 7? You could vote for Article 7 now, and they haven't, right? Instead, they're saying, why don't you try something else before we get to Article 7? Okay, so what's going to happen? Well, many people expect, Article 7 is going to fail. Because you can see that every time this thing gets to the council, whether it's on the Hungarian side or on the Polish side, the council refuses to engage in disciplining its fellow member states. And so this is one of the things we're really worried about. So what's left of judicial independence? Well, after this week, it'll be gone in Poland. It's already been gone in Hungary for some time. Although I must say that individual judges in both places are trying to stand up to it, but it's very hard to do that when the whole system is designed to crush you. All right, so why isn't Europe more effective? Okay, and this has to do with really the structural arrangement of the EU. The EU engages in what I call the logic of partition, right? So, and this is where, as the introduction said, I come at this from the constitutional law of the member states into EU law. And this problem looks really different seen from the national level than seen from the EU level. So the functioning of the EU depends on having member states that meet all these criteria for democracy and rule of law and protection of human rights. But those forms of government are outside the competencies of the EU, right? And that's because the EU is a system of conferral and subsidiarity. Unless the member states have agreed to confer some specific power on the EU, it has no power to act. And therefore, there's a partition between the subject matters covered by EU law and the subject matters covered under national law. What's outside of EU law? Well, everything. Then constitutional systems. What kind of form of government? What's the structure of your judiciary? What kind of election system do you have? I mean, there's been an allegation now that Hungary's had 2 elections that were not free and fair. Does the EU have any control over election law? No, right? So what you see is that the EU relies for its integrity on things outside of its legal control by virtue of the way the EU is set up as a partition system between national and transnational law, right? So none of this is in the scope of EU law. So the problem is then that creates, just like with the euro crisis, where you've got a common currency without a common fiscal policy, or the migration crisis, where you've got a common asylum policy but not a common immigration policy. The crisis here is the same kind of structural crisis, where you've got a system that relies for its integrity on stuff outside the system that the EU can't control, right? It's the same problem here as in those other issues. Now, where does this come from? Well, this comes from Article 4 of the Treaty of the European Union, which first of all says any competence remains with the member state unless it's been conferred. And then this is the part that now nationalist governments in the EU love, because everyone's claiming constitutional identity, even though the language is national identity. But literally Article 4.2 says, the Union shall respect the member states' national identities inherent in their fundamental structures, political and constitutional. That's the stuff that these 2 governments are playing with, right? And Article 4.2 looks like it protects them. There have been an increasing number of governments now in the EU and courts in the EU, national courts, that have been claiming and walling off big parts of their constitutional law under the guise of constitutional identity. There was a big decision of the Hungarian Constitutional Court in December 2016 trying to wall off Hungary from application of the EU sort of migrant relocation program. And now the 7th Amendment to the Hungarian Constitution passed 2 weeks ago now puts this into the Constitution and says that it is the obligation of every Hungarian state body to defend the constitutional identity of Hungary. Okay, so this is like really drawing the legal dividing lines. So what can overcome it? Well, there's still Article 4.3, the loyalty principle, right, which says member states shall refrain from any measure which would jeopardize the attainment of the Union's objectives. But are these things really Union objectives, right? The logic here, this is the provocative part, right? The logic here, some of you I see recognize the book, right, is the logic of the dual state. Okay, now I don't want to say the EU is a Nazi perpetrator. I mean, so the dual state was a book written by Ernst Fraenkel, a Jewish lawyer writing in 1938 in Berlin. He said, what's it like to live here as a lawyer in 1938 Berlin? He said, what we have is a dual state, where part of the state is what he calls the normative state, where rule of law is followed, where all the rules are played out as announced. All the rule of law criteria apply on the side of the normative state. And then there's a little partition, and then there's what he called the prerogative state. And if your case gets moved across the line by the arbitrary actions of government, no rule of law applies to you. That was the structure, he said, of the Nazi state. Okay. Unfortunately, this is also a bit the structure now of the EU, where within the EU, I mean, we're still seeing in all the other lectures that you've seen over this week and next, that there are still immense legality and rule of law problems in the EU law box. But the question is what's happening on the other side of the partition, and who controls where that partition is, right? Because that's really the dilemma that we're facing with these states now. This is the literature, so when you find EU defenders, this is the literature on constitutional pluralism, which is meant to be a strength and a wonder, and lots of defenses of constitutional pluralism. But once you start to see what's happening in Hungary and Poland, what you've got is a gap between a normative state and a prerogative state, right? Where there's EU law scrupulously followed on one side of the line and not on the other. So what does this partition look like in national law? Okay, and this is where, I think it's important to see this both from the EU law side and from the national constitutional law side. The EU has survived so far because judges in the national courts think that they should harmonize across the national law system and the EU law system, even though they're not legally required to. Right? Ditto with European human rights law. So you see judges thinking, well, in this territory, people shouldn't be commanded to do contradictory things. There shouldn't be two separate legal orders that operate in no conversation with each other in this space. And Nico Krisch's work is very good on this stuff, where you see how the national judges have really harmonized this into a common picture. But what if you have a government that says to the national judges, no, you can't do that? Or you have a government that sets up a separate judiciary, as the Hungarians are now doing in administrative law, where all those topics are not EU law topics. So you've got a set of courts that don't touch on the subject matter of EU law. So who controls the partition and whether this is a coherent system? Now, this hasn't arisen as a problem in EU law, and the reason why is, as the EU, as the ECJ will constantly say, this is an autonomous legal system. And the ECJ does what it does by ignoring everything at the national level. This is why it doesn't matter to the ECJ if a provision that it's overriding with EU law is in the Constitution or not, right? Because all of that is just completely irrelevant. So from the standpoint of EU law, it still looks like there's a coherent legal order. But of course, everybody who lives in the EU also lives in a member state that has its own legal system, and that's not controlled from the standpoint of EU law. So imagine an EU member state, and I show here some members of the far-right party Jobbik in Hungary burning the EU flag, which they do on occasion. Imagine that you get a government that just figures out, really good lawyers, they figure out what EU law applies to, and they create one set of institutions that scrupulously apply EU law, and then another set of institutions that doesn't have to, because it's outside the subject matter area. That's where we're heading. Hungary is ahead of Poland in this regard, but this is where they're moving to. Okay, so what is to be done? I'm going to run quickly through some options. I'm afraid I'm sort of pessimistic about all of them, but I at least want you to see that there's some hope, and I hope that you'll start to think about what can be done about this from the EU law side, from the member state side. So the first is to go back to Article 7.1, right? So it's still worth using Article 7.1 even if it doesn't do much. Sort of the same way that you sort of hoped somebody stood up in 1930s and said something about what was happening in Germany. At least somebody's noticing, right, that I'm not saying it's exactly the same thing, but at least somebody's noticing that there's a really big problem. The problem is, of course, that Article 7.1 is just a warning. And to get to Article 7.3, which is the part that actually applies sanctions, You got to get through the hurdle of Article 7.2, which is the part where you need the unanimous agreement of member states. And what you've got, actually here, the cooperation between Hungary and Poland, is that Hungary has said it will veto any sanctions against Poland and vice versa. So I've made a proposal that's been making the rounds, and that sort of relies on the fact that you're now seeing some movement toward Article 7.1, toward Hungary on the Parliament side, toward Poland on the Commission side. The Council has yet to act in either case. But still, suppose that you could get Article 7.1 in both cases. Then this is my proposal, that no members, it says in the treaties there has to be a unanimous vote at the stage 2, Article 7.2. But I think it's quite possible to argue that if any state is already under an Article 7.1 warning, they should be disqualified from voting in Article 7.2. I'm relieved to see a lot of you nodding out there. That's good. And why? So many of you know this doctrine of effet utile, which the Court of Justice uses often. What's the point of Article 7 if it only applies if you've only got one deviant member state? And as soon as you get two, all bets are off. It's crazy. You can't have the most serious sanction disappear when you have more than one state in that situation. So my proposal has been to go ahead with Article 7.1 in both cases and then try to make the case. This is probably going to have to get challenged before the ECJ, but we know how they feel about effet utile. You know, maybe this will work, and maybe then you can get to Article 7.3. I think the Commission can also improve the way it brings infringement actions, which is its main, bread and butter daily way of trying to get member states to comply with EU law. But they have to get much more ambitious. So right now, the Commission tends to bring infringement actions, little specks of criticism against individual clauses of individual laws. And what we've seen in the case of Hungary particularly, and now Poland's getting better at it, is that they can easily evade that by changing the one clause that's objectionable, especially after they've already captured all the courts, for example. So what the Commission needs to do is to think more holistically about what's going wrong here. And so what I've argued for, and actually the Commission Legal Service has accepted in principle, is that they should take a whole package of stuff, right? So think of all the ways I showed you that Hungary has challenged the independence of the judiciary. The Constitutional Court, the ordinary courts, the selection process, the disciplining process, they've captured all of it. Ditto in Poland. Why not put all those things into a single infringement action and then raise the stakes on what's going on here? This is not just age discrimination. It's not just, some violation of some small part of the acquis. This goes to something more major, right? So here are three options. You could say, among other things, it violates the Charter. And actually now, routinely in the Hungarian and Polish cases, the Commission Legal Service is now sticking in CFR violations in almost every infringement action they bring. Good. But they could do better. What if they start putting in Article 4.3, right? This looks like a systematic effort to derail the ability of EU law to function in the country if you've captured the entire country's judiciary. Because as we all know, judiciaries are dual-use judiciaries. They apply EU law. They're the courts of final resort for the vast majority of EU law cases. And they apply national law. That's why if a country sets up a separate set of courts for national law only, this is a bit of a challenge to this. But still, right now, you've got this possibility of saying, this is a violation of Article 4.3. And when I started making this case about 5 years ago, that the Commission should be able to litigate directly the values in Article 2, everybody said I was crazy, and now there's a law review literature that says, well, why not? Right? Why not directly litigate? If those values underwrite the whole system, bring an action that the country's violating the rule of law. The advantage of doing this is that if the ECJ agrees that there's a systemic infringement, then you get systemic compliance, right? Then the ECJ can say, fix the independence of the judiciary, not just compensate the judges who were prematurely retired, right? So it gives them a lot more options. And I think this would eliminate some of the legalism and the response we've seen to the ECJ judgments. And then, and this is still the proposal I don't have anybody in agreement with me on, but I'll throw it out there anyway, which is to say that, if the country is not in compliance, then the Commission can go back and get an action under Article 260 for a fine. Okay, so you can fine member states. We all know it hasn't been all that effective. But what if instead of requiring the fine to be paid from the treasury of the country, you deduct the amount of the fine from the funds that would otherwise flow to that state from EU coffers and just suspend the money until they comply? All right, nobody's bought that one yet, but I thought that was a good idea. What the Commission has started to do, though, is to start thinking about how to get to the funds, right? Because at least what the EU can do is to stop funding the governments that are sticking their thumb in its eye. So there are now a couple proposals on the books. So one is that just a few months ago, the Commission came forward in conjunction with the multi-annual financial framework with a proposed regulation that will link the various streams of structural funding to rule of law compliance. Of course, Hungary and Poland have already started screaming, and so far nobody's showing any speedy movement toward enacting the regulation, but at least it's on the table for discussion in conjunction with the next budget. There's also a proposal now that we have this enhanced cooperation agreement about the European Public Prosecutor's Office, that no member state should get funds from EU coffers unless they agree to sign on to this, because how else are you going to prosecute fraudulent uses of EU funds unless the country is signed on to this? Hungary and Poland are so far refusing, but this is something that at least some member states, Germany and the Netherlands, have been insisting on. And finally, and this is where I'm going to get to where you guessed we were going, the European Court of Justice has been watching this with great concern. Some of the judges have actually given speeches at academic conferences indicating that they see this as one of the most fundamental threats. Because unless you have an independent judiciary, in particular, across all the member states, you don't really have the EU. So, what happened? Well, there was this case decided in February, which is from the Portuguese Union of Judges. It was an austerity case, so it links to the lectures you've been hearing on the Eurozone crisis. In Portugal, which was operating under a series of MOUs to cut back state funding, the Portuguese government cut the salaries of all public sector employees, judges included, by 5%. The judges sued. This violates our judicial independence. The Portuguese court sends a reference to the ECJ and says, the EU is making us do this. Does this violate judicial independence? And you can guess how that would come out, right? The ECJ is always going to say the union must, So they say there's no problem with judicial independence. Austerity measures are fine as long as the judges aren't just singled out, as long as the cuts aren't so major that their livelihood is really endangered. And then, completely without any need to, the court then said, but by the way, judicial independence is a really serious thing, and all EU member states are obligated directly under the treaties to have an independent judiciary, regardless of whether they are applying EU law or not. This is the step the Commission hasn't been willing to take, right? And here's a little bit of the language. The member state concerned must ensure the courts meet the requirements essential to effective judicial protection. They cite Article 19.1, right, the structural part, which is not, and the way the court reads it, not limited to EU law alone. So every member state must maintain a court or tribunal's independence. What does this consist of? It requires not just the EU level, but national courts. The independence of national courts and tribunals is essential to the working order of the judicial system. And here's what it is. The body concerned must exercise its judicial functions wholly autonomously, protected against external interventions or pressure liable to impair the independent judgments of its members or to influence their decisions. ECJ language. Think about what's happening in Hungary and Poland. And then, in case anybody missed the relevance, protection against removal from office constitutes, a guarantee essential to judicial independence. What's happening in Poland this week? Okay, this is waiting. So, the ECJ's opening was seized. There was an Irish judge who comes along, and she's got a couple of European arrest warrant cases to send people back to Poland. And she looks at this and says, how can you send, she read the Commission's reasoned opinion on Poland, and she said, how can I send anybody back there if the courts are not independent? She sends a reference to the ECJ. And this is a quote from her judgment. She said, the reasoned proposal of the European Commission is by any measure a shocking indictment of the status of the rule of law in a European country in the second decade of the 20th century. It sets out in stark terms what appears to be the deliberate, calculated, and provocative legislative dismantling by Poland of the independence of the judiciary, a key component of the rule of law. This is an Irish judge. Don't you agree, she says? What happens, what are we supposed to do with the case law on the European arrest warrant, which presupposes mutual trust, right? You're not supposed to look under the hood of some other country's legal system before you transfer individuals back under the European arrest warrant, under the Dublin regulation, etc. Okay? So she's asking, do you really want us to actually go and look at whether the individual can get a fair trial? Isn't it enough to just say the system is rotten? And unfortunately, last week, the AG, Tonchev in this case, came forward with his opinion. And basically he says, no change. You can handle this under the previous case law, Arnyoshi, if you know the European arrest warrant litigation. And the judge has to first say if there's a systemic problem, that's up to the judge to decide, the executing court judge to decide, and then that judge still has to say, will this individual get a fair trial? Will this individual get a fair trial? Reduces it to an individual right, doesn't think about structure, only mentions Article 19 in a footnote, only mentions the Portuguese judge's case in passing. It's as if the AG doesn't think the Portuguese judge's case applies in the context of the European arrest warrant. So where are we now? Well, this is where the fact that the Commission filed this action on Monday, citing Article 19.1, that may be the vehicle through which the ECJ actually finally reaches this case, and not through the European arrest warrant case. We've got the European Parliament suspended to vote on Hungary, Article 7.1 in September. We've got the Council sitting on this reasoned proposal from the Commission to approve Article 7.1 against Poland. There's all these efforts to try to cut funds to Hungary and Poland, and the ECJ has opened up the door. But there's still the problem of the partition. And the question is whether these countries are going to respond to this next wave of potential pressures by essentially boring in on the partition and setting up separate institutions, one that handles EU law matters and one that handles national matters. You already see the Hungarians going there with the administrative courts. The Poles usually follow suit a little bit later. This is going to be a problem that goes to the very structure of whether the EU can maintain itself as a rule of law system. And it's going to take a unified EU to save the fundamental values of the Union, and unfortunately, that's what the EU looks like right now. Thanks.